Okay, I've gotten gone through some decisions made in Natchitoches now. Some important decision points were made, just simply because of my let's say it's like I feel like I'm being responsive, but the court is not accepting my responsiveness. The court in Natchitoches requires very limited responsiveness. I have emailed the court motions and called on the very day of the hearing that was scheduled for the 28th, and I made sure to record that. That was a hearing where I talked to a clerk who just said that the judge was already in court and couldn't talk to me or something. Prosecutor was there, but it was the clerk who's like unable to walk, the disabled clerk, so she couldn't really check anything. She can't walk anywhere. Her legs have given out on her. So I try to document from a distance because there was that snowstorm that happened about the 20th that really had me concerned about my safety. Scared. I was very scared of suffering, and it's all over. It's like that's how the court is. They're like, oh, you survived, all right, but we're back to normal. It's like, yeah, there's no aftermath afterward. You survive, that's it. And that's the attitude that the civil court Judge Dias takes. Oh, you have one warning. That's where the prescription date starts, or what the normal people call statute of limitations. The Louisiana redefines it so they can twist it and bend it and stretch it out. They change the wording of things a lot. And that's what they did recently with that reading comprehension thing as well, so that they boosted themselves up by 10 states. How do those other 10 states feel about Louisiana suddenly exploding ahead of them on reading comprehension? Do they believe it? Do those 10 states believe that Louisiana suddenly got the edge on reading comprehension? But the judge, he made some rulings on the 28th, and it sounds like I'm facing like 2 contempt of court hearings. One is simply failing to appear, and the other, it sounds like something else. I have a rule to show cause, and I think the rule to show cause, which I asked for that paperwork and haven't received it yet, I think that's for the other thing, which if I were to make my best guess, is the judge has reason to believe I'm not in Louisiana anymore. Just a guess. He might have some information about me violating our bond conditions that I signed, promising not to leave the state. Because he revoked it, which is shows in the minutes. So I have my minutes, my court minutes. I have two things. I have my court minutes and I have my warrant for arrest that the clerk gave me copies of. And I have to ask individually, of course. They don't just volunteer that information. I read into the minutes and I see, oh, there's a rule to show cause. Usually the rule to show cause has to be handed out personally by the city marshal. So he's not able to find me in the Natchitoches County. So I'm asking for it over email. I want to see it and get familiar with the wording of what that has to say. Usually it's not very revealing, but maybe it'll give me some insights. I think I'll want to file a motion for discovery on that rule to show cause, which has a set date of February 10th. I want to file a motion for discovery on that, but I want to see it first. Alright? Because this case is still active, but I'm just not able to participate remotely with them. So they're gonna just act like I don't exist unless if I show up in the courtroom. There's no communicating outside of the courtroom, or there is, but they just have excuse after excuse. I'm untimely. They're confused about what I'm asking, or I didn't write an order apparently for a couple of motions. I didn't write an order for the judge to sign, so he denied it based on that. And if I had wrote an order, then he would just simply say it wasn't filed. Because, I don't know how they work it. I asked in my last two motions, which I filed over email, the judge acknowledged them in the court minutes, but he just said there was no order that I wrote, so he denied them. And the first time I missed court, it was just simply him stating that I didn't show up, so I lost. They were denied simply because I wasn't there. And that's the case again. They got their tricks, and I'm learning. I try to participate as much as I can so I can learn what their deal is. Try to understand. Oh, it's this. Oh, it's that. We're gonna blame this. We're gonna blame that. They just go back and forth. So they call them pitfalls. They like to use the word pitfalls a lot because court has a lot of pitfalls. You just jump over one, but fall in another in court. They do that to each other. They do it to the uneducated. They love watching the uneducated fall in pit holes. They love to make each other fall in pit holes. I seen it done with Judge Ousley against my former lawyer, making him fall in a pitfall over filing 3 motions at once and saying like 2 of them don't apply because they were untimely. They should have been filed before one motion. You gotta look at your motions as being a timely thing. You don't file a discovery request after you're convicted. But that's an obvious one. There's even more detailed stuff, and the judges will give some people time and take other time away from people. They'll give and take time. So you gotta like somebody told me, you gotta wait in a lot of cases. There's some things that you have to get prepared before you're ready to file. You have to have step 2 ready before you file step 1, and then file step 2 immediately after, and make sure it doesn't step over a jurisdiction of another thing. You don't want to. You can't file with the appeals court and the city court at the same time. Okay. He's going. That was quick. All right. Yeah, I'm going a little too slow, I guess. So, yeah, I have a court date coming up, and I think I got a warrant. Whether I'm on the NCIC or not is something I'm not aware of yet. Either they learned their lesson from the first time, or they just decided to do it again. And I haven't even bothered to check. I have a feeling that they're gonna wait on putting me on the NCIC until after my trial date. I never checked. I'm curious, but I never checked. But I mean, based on the first experience, they probably didn't like that. I was turning myself in, and then they had to take me off the NCIC and just keep me on the warrant announcement for only the state. Not put me on the national database. They might think they're being cheeky, not putting me on the NCIC. Just wait until after the trial date, then put me on. That's what I expect. I didn't look into it. The chances of me getting arrested for anything are pretty low, but it could happen. And then, I'm in Texas, so Texas can find out if I have an arrest warrant in the city of Natchitoches. Under a state law, though, this isn't just a city offense. Although only the city judge can try me on it. A state law being tried in a city court. It's giving the kangaroo court the extra power. But I got these problems that I can't quite ignore, but I can a little bit. Ignoring it really helps with my stress levels. So just kind of ignoring it helps. I'm learning a lot about the tactics. I recently got some training information from my arresting officers in West Milwaukee, and it's got me kind of in some rabbit holes to jump in about cops training for trials. They get 8 hours of training in Wisconsin. In Louisiana has less time for training, that guy is. So they probably have half. But I gotta say, Officer Davis was acting in a way that gave me the impression that he did get some training for testifying. He was asking me to ask my question over again. He was asking me if I was asking him his professional or personal opinion. That's stuff that he learned as part of his police training. And now that would trigger me to ask him how much training he got for trial. Because he was demonstrating that he had training, he got training by asking very keen questions about the matter. And I mean, there's a lot of tricks that the cops want to use, and I want to make my questions overcome those cop tricks. At first, in my training about asking cross-examination questions, I was concerned about the prosecutor objecting, but now I'm less concerned about the prosecutor objecting and more concerned about the cop using tricks. That seems like the greater concern. I'm ready for the prosecutor objections, and I'm less inclined to object to the prosecutor and just simply remember just write down what they asked and use that as cross-examination questions more so, unless if it's really blatantly a crazy question. Speculation, obviously speculation, that's easy to object to. I don't want to be objecting to everything. And I kind of don't care if a prosecutor objects a lot to me. I think that if I gear my questions in a way that can overcome the cops playing their tricks on me, that I'll probably overcome the prosecutor's objections as well. There's a standard, there's a couple of levels of standards, and some levels are more important than others. And this isn't just some random witness on the side of the road. I'm asking that, if somebody, I'll be asking questions of people who are trained, who spent 8 hours in Wisconsin, have spent 8 hours training to survive their questioning. So I want to have my questions ready for that. And I want to ask, I want to bring it out in trial, especially for West Milwaukee. I want to ask questions that make it clear that this cop was trained to answer questions. This cop was coached by the prosecutor. They spent time with each other and went over certain questions. And I mean, the AI is helping out with determining the best way to ask these questions. And then I submitted on my channel the judge, how to annoy a judge. And I mean, I didn't make that up. I just asked the question and I got a big response, and it's very interesting. But I mean, these are things that I mean are perfectly within my rights to do. I mean, you can't annoy AI. I don't know why I should be worried about annoying a judge. A judge is supposed to be like AI. They're supposed to be rational and controlled and not emotional. They're supposed to be like AI. And as far as logic goes, this isn't politics. This is supposed to be logic and reasoning, which is the cornerstone of AI. And I'm asking AI how I would annoy it, but you can't annoy AI. So there's things going on in my with my legal problems, but yeah, I just keep trying to learn and learning with all this stress. I don't know, it's a way to do it.